Welcome! This video is for people who are either starting or responding to a divorce case. If you are the petitioner opening the case, make sure you've watched the Starting a Divorce Case video first. Here, we will explain the process of completing your mandatory financial disclosures. In the state of California, declarations of disclosure are mandatory documents that married couples exchange to disclose asset, debt, and income information with one another. You can think of this as an exchange of all of your financial information, including bank accounts, properties, debts, monthly expenses, and income. When you do these now, they are referred to as your preliminary declarations of disclosure. Later on in your divorce case, you will submit your final declarations of disclosure, as your financial situation may have changed by the time your case is finalized. Both parties must complete this process, so whether you are opening the case or responding to it, this will apply to you. In addition to the court forms you'll fill out, disclosures also include some documents that you must gather on your own, which will not be filed with the court, but the other party will receive. We'll explain more about that later. These forms are mandatory. There are no exceptions. Even if you feel that you don't own or owe anything, or not very much, you still must complete these forms and this process before your divorce can be finalized. Even if your spouse already has access to your financial information, or if your property is shared between you, you still must complete these forms. Similarly, even if you do not want your spouse to know your financial information, or you have not spoken in years, you still must complete these forms. Even if you already have an agreement with your spouse regarding division of your property, these forms are still required. The logic behind requiring these forms is that by sharing information about everything you own and owe early in the process, the parties are more likely to be able to come to an agreement or be prepared for trial. One part of your declarations of disclosure is your income and expense declaration, where you provide information about how much you make and spend each month. Job information. First, you'll enter information about your current job. If you are not working right now, you need to list your last job, even if it's been a long time since you worked there. You'll also be asked about your education and any training qualifications or licenses you possess. Income, now and over the last 12 months. The court requires that everyone provide information about their income. You will need to indicate your income over the last month, which means adding up everything you earned during the last calendar month and your average income over the last 12 months, which is going to be everything you earned for the last 12 months until today's date divided by 12. For some people, these two numbers are going to be the same. For example, if you've had the same job for a while and haven't had a raise in the past year. For other people, these numbers might be very different. If you are only working seasonally, or if you started or stopped working at any point during the past year, these two numbers could be very different. You will be asked about different types of income, including salary and wages, overtime, Social Security, cash aid, disability, retirement payments, unemployment, and more. If you earned income in more than one category, you will separate and list each amount. Child support is not considered income. You must attach proof of income for the last 2 months. For most people, this will be copies of all your pay stubs from the last 2 months. If you're not working but have income, your proof of income might be unemployment stubs or proof of your workers' compensation or a letter detailing your Social Security retirement payments. Because you are filing these documents with the court, make sure to black out any Social Security numbers or bank account numbers from your proof of income. Estimate of the other party's income. When you fill out your forms, you will be asked for the other party's income. If you do not know this information, you will have to make a good guess. If you believe that they do not have any particular education or work history, one option would be to say that they are capable of making minimum wage. But for many people, that will not be a very accurate guess. You may be able to make a better estimate by recalling what they made when you were together. If you saw their paychecks, what they told you they make, what they paid each month in expenses, or by doing some research online as to what people with similar backgrounds make at their jobs. Do not leave this blank, as the court will assign minimum wage to the other parent's income if their estimated income is 0. If you are asking for support, it's especially important that this is accurate. Household income and expenses. You will also be listing your household's income and expenses. If you're living with your spouse or other family members, including your children, this is going to include their income and expenses. However, if you are renting a room or have a roommate and you just pay your share of the rent, but otherwise don't share expenses with them, for example, groceries, then you don't need to include them as household members. You'll list what your household spends each month on different types of expenses. For example, rent, groceries, childcare, and any loans, credit cards, or additional bills you pay each month. You'll also be asked about expenses for your minor children, such as daycare and health insurance. Another part of your declarations of disclosure are your property declarations, where you'll be asked to list every item you own and everything you owe. To do this, you'll need to list all of your community property, all of your separate property, and all of your spouse's separate property. To do that, it's important to understand the difference between community and separate property. Community property is anything that was earned or spent from the date you got married to the date of separation. It doesn't matter whose name is on the title or the account, who paid for it, or who actually has the item. In general, everything earned during the marriage is community property and belongs equally to both spouses, even if one of you was not working during the marriage. It also doesn't even matter that you both agree who's going to keep that item. You still need to list it in the correct separate or community property category. If you are going to make an agreement, you can agree to anything. However, you still must list everything: yours, theirs, ours, or the court will not accept your agreement. If the court has to decide, everything will be divided 50-50. For example, if I am married and working, and I take some of the money I earn and put it in an account with just my name on the account, and then when I have enough money, I buy a car and I put the car's title in my name, and the car is only insured for me, who owns that car? I only own 50% of that car, and my spouse owns the other 50%, even if my spouse wasn't working during that time. Conversely, if I spend $1,000 on clothing for myself, on a credit card in my name alone, that is still community property debt, and my spouse still owes 50% of that amount. Remember, though, that my spouse and I can agree on anything that we want. If my spouse wants to be nice and say, I can keep the car, we can do that. If I want to be nice and tell my spouse that I will pay the whole $1,000 clothing debt, we can do that. But that doesn't change the fact that those two items are community property. I still must list them as community property. In California, separate property means anything that either of us earned before marriage or after separation, and anything that we got by gift or inheritance at any time. So if my spouse bought a car and paid it off before we got married, that is my spouse's separate property. I still need to list it, and I will assign it to my spouse as their separate property. If I opened a credit card after my spouse and I separated, then I need to list that card as my own separate property. If you have student loans that were taken out during the marriage for one of you, those are generally assigned to the student even though they were taken out during the marriage. There are exceptions, so speak with a private attorney before filing your paperwork. If you believe that your spouse caused debts during your marriage that were not for the benefit of the community, meaning, for example, that your spouse was engaged in illegal activity that you didn't know about, or that your spouse spent a lot of money on an affair, you may be able to claim you shouldn't be responsible for half of these debts. If that's your case, speak with a private attorney. If you need legal advice about these issues, we suggest you speak with a private attorney. The Self-Help Center is unable to give you advice about how to list or divide your property. Let's discuss the kinds of things you'll be listing. Property includes everything you own, called assets, and all debts you owe. For each asset, you will list the current market value, not what you paid for it, but what could you reasonably sell it for now at a yard sale or on eBay or Craigslist. You will also need to list when the asset was acquired. When did you purchase it? Or if it's an account, when did you open it? For debts, that means when did you incur the debt? Real estate. This means houses, land, or other real estate you or your spouse owns. For each property, you need to list the full address, and you also need to know the current value of your house. If you don't know the current value, you can talk with a realtor or go look on a website like Zillow.com. This will give you a rough idea of the value of the house. If you end up going to trial and you and your spouse cannot agree on the value, you may need a formal appraisal. You also need to know what you still owe on the house and when payments on the house were made. Were they made with money earned before marriage, during marriage, or after separation? Even if a house is separate property, you must list it so it will be included in your divorce judgment. Otherwise, you will not have clear title and may not be able to sell it without returning to court. Cars. Just like with the house, you need to have a specific description, the year, make, model, and either the VIN or the license plate number of the vehicle. You need to know the current value of the car and the amount that is owed on the car. Remember that the current value will be different than what you originally paid for the car. If you don't know the value, You can look it up online at a site like kbb.com, the Kelley Blue Book site. List all cars that you know of, including those purchased after separation. You do not want to be responsible if your spouse gets in an accident or gets tickets. You also do not want your spouse's creditors to try to seize your vehicle. Bank accounts. Again, you need to have a specific description: the bank name, the type of account, whether it's checking, savings, or money market, and the last 4 digits of the account number. Please be aware that anyone can come to the court and look at your file. So although you should list the last 4 digits, you should not list any more than the last 4 digits. For each account, you need to know the current balance as well as when the money was earned. Was it before marriage, during marriage, or after separation? Retirement accounts and pensions. It can be especially important to get orders related to retirement accounts. Take a moment to think about if you are overlooking a retirement account. If you work or previously worked for the state or the county, or you are a public school teacher or work for a large hospital or big grocery store, or work anywhere with a large union, you may have a pension. For each of these accounts, you are going to have to determine if they are community or separate property. For many, pensions or retirement accounts are partially community and partially separate property because someone started a job before they got married, and then the retirement plan or pension grew while they were married too. For IRAs, 401ks, or 457 accounts, your company can give you a good estimate of the account's value. If you and your spouse disagree about these accounts, you will need additional information. For pensions, you will likely need to get a professional assessment to determine the value. Remember that even if you want the other person to keep their retirement or they want you to keep yours, you need to list these accounts on your divorce forms. You don't want to get to retirement age and have trouble getting your retirement pay because your divorce judgment doesn't say the retirement plan is yours. The retirement plan could decide that they don't want to pay out without a court order specifying that it goes to you. Even if you didn't start working at the company until after you separated, the employer doesn't know that and may just decide they want to protect themselves by requiring a court order. It can be a lot harder if you have to get a court order in the future than getting it now. You would need to file court forms and have your spouse served, even if you haven't had contact with them for decades, so that could be extremely difficult. If you have significant retirement accounts, it's a good idea to talk to a private attorney for advice. Household items. You don't have to list every single item of furniture in your house. It's okay to use categories such as living room furniture, or if you have already divided your furniture, you can write all household items in petitioner's possession and all household items in respondent's possession. However, if there is an item that is particularly valuable, either sentimentally or financially, that item is going to need to be specified. Businesses. If you or your spouse owns your own business, you must list it in your property declaration. Dividing a personal business can get quite complicated, so you may want to speak with a private attorney to get legal advice. In addition to listing everything you own, part of this process is listing all of the debts you and your spouse owe. If you feel like you can't remember all the debts that you owe, you can request your free credit report through the Federal Trade Commission. If you are asked to pay money to get your credit report, you are not on the correct website. Be sure to go to the government website. Again, you need to be specific when listing your debts. For credit cards, you must include the name of the company that issued the credit card, such as Discover or Chase or MasterCard, the last 4 digits of the card number, the amount owed, and when the money was spent. For some people, these debts tend to start accruing when you separate, because you now each have to pay for a household, so your expenses are greater. Be sure to list any loans, including those from family members or friends, tax debts, money owed to landlords, etc. If there is something that isn't specified on the forms, please add it in the section Other. If you have horses, a patent, or some sort of collectible we didn't think of, still be sure to include it. If you have any questions about how to divide your property, please talk to a private attorney, as the Self-Help Center is unable to answer questions about your specific property. In addition to the court forms you will fill out, you will need to serve your spouse with some additional documents. For every item you list on your property declarations, you need to include some form of proof. We call these supporting documents. For example, for every bank account, retirement account, or credit card you list, you need to provide a copy of the latest statement. For any vehicles, you need to provide a copy of the title. These are just a few examples. If you're unsure what supporting document to use for property you've listed, look on the last page of the property declaration form for guidance. It's okay to black out all but the last 4 digits of the account numbers to protect your privacy. Also, you will need to provide your last 2 years of tax returns. It doesn't matter if you filed taxes with your spouse during either of those years, you still need to serve them with copies. For all of these additional documents, you must not file them with the court. They all get served on the other party, but do not go to the court. Anything you file with the court becomes public record and viewable by anyone, so do not file these personal financial documents. Only give them to your spouse. The only financial documentation that does get filed with the court is your proof of income, which you will attach to your income and expense declaration. In one California county, there was a famous case in which the wife was part of a lottery pool at work that won $7 million. Her share of this was $1.3 million. She decided that she would try to avoid disclosing it in her divorce. After the divorce was finalized, her husband accidentally learned about her winnings and he took her back to court. She tried to argue that the lottery winnings were her separate property. What do you think the judge did regarding the lottery winnings? The judge didn't just give the husband 50% of the lottery winnings he would have been entitled to if she disclosed them. Instead, he decided that they should be awarded 100% to the husband because she failed to disclose the property as required by law. The moral of the story is, if in doubt, disclose it. If you are the petitioner or the person starting the case, you should continue with the instructions from the Starting a Divorce Case video. If you choose to fill out your forms using either of the online websites, you will be asked to enter your financial information then, and the financial forms will be prepared for you. If you choose to do the forms by hand and download them from the Self-Help Center website, you will need to separately download the mandatory financial disclosures packet in addition to the divorce petition packet. The packet includes all of the separate financial forms you'll need to complete. The law requires that you complete and serve your preliminary declarations of disclosure within 60 days of filing your divorce petition. We recommend following our instructions laid out in the virtual divorce workshop to complete your financial disclosure forms at the same time as your divorce petition and filing and serving them all together. Additionally, the Self-Help Center will only review your divorce forms if you have already completed and included the financial disclosure forms. If you are the respondent in the case, you also need to complete these financial disclosures. You can use the online program, guide, and file, or download the forms from the Self-Help Center website to complete them by hand. Your disclosures are due within 60 days of filing your response. So, if you want to streamline your response, you can file and serve your response and preliminary declarations of disclosure at the same time. Make sure to follow the instructions laid out with the forms when you download them. If you need additional help with your mandatory financial disclosures, please visit the Preliminary Declarations of Disclosure workshop on the Self-Help Center website. That workshop will also explain each individual form, so if you are choosing to fill them out by hand, it's recommended you use that workshop video as a guide. If after viewing the workshop video you have further questions, please contact the Self-Help Center for assistance.